All right, so let's continue talking about this final rule that amends the definition of a qualified employer under public service loan forgiveness. This was just announced today. It's going to be published in the Federal Register tomorrow. But if you are someone and you are seeking your discharge of your student loans under the Public Service Loan Forgiveness Program, and you know that your discharge will not happen until well after the 1st of July 2026, then it's important that you have an understanding of this rule because it could affect you potentially. So you want to understand what happens and how the department is defining what is a qualifying employer for the purposes of public service loan forgiveness. All right, let's talk about it. Okay, so this is the fact sheet. We already covered pages 1 and 2, the definitions of a qualifying employer. Now we're on employer determinations and reconsiderations. And just so that we can make sure that no one is stressing out about this, okay, as of right now, the effective date, it tells you in the fact sheet, the final rule will be effective on July 1st, 2026. It provides borrowers and employers ample opportunity to understand the impact on them and take any necessary actions. As stated above, the rule does not change the underlying law. It establishes consequences for breaking the law. Only illegal activities that occur on or after July 1st. So right there, on or after July 1st will be taken into account when the department takes enforcement under the rule. Okay, so we know this isn't taking place until after July, on or after July 1st, 2026. So we're going to go back up where we started off. We've already covered pages 1 and 2. Go back. If you have not a video, you'll see where it talks about the definition of a qualifying employer. But where we are, employer determinations and reconsiderations. In this final rule, the department establishes a process for determining that employers have a substantial illegal purpose and may no longer be a qualified employer for the purposes of the PSLF program. The secretary will determine by preponderance of the evidence and after notice an opportunity to respond that a qualifying employer has engaged on or after the 1st of July 2026 in illegal activities such that the organization has a substantial illegal purpose by considering the materiality of any illegal activities or actions. The final rule outlines specific evidence that the secretary may find inconclusive when making a determination, including a final judgment by state or federal court, a plea of guilty or nolo contendere, or a settlement by an employer that includes an admission that engaged in illegal activities such that it has a substantial illegal purpose. Employers will be provided with a notice, a transparent record, and an opportunity to review, respond, and rebut the department's finding, providing due process to all impacted stakeholders and apply the rule fairly and consistently. Qualifying employers that are under review because they have a substantial illegal purpose will maintain qualifying employer status until a final determination is made by the secretary. Okay, so this is a part of the determination